case briefs, and so much more. LSData's got what you're looking for.
In 1995, the United States Court of Appeals for the Federal Circuit heard the case of In re Deuel, which focused on whether a patent application for heparin-binding growth factor was obvious and thus unpatentable. The patent would cover isolated and purified DNA and cDNA molecules that stimulate cell division and tissue repair. The U.S. Patent and Trademark Office initially rejected claims 4, 7 of the patent application based on the combination of prior art presented by Bohlen and Maniatis, arguing that the invention was obvious. The court, however, reversed the office's decision, arguing that the claims were not obvious in light of the applied references and that there were no structurally similar compounds in the prior art. They determined that claims 5 and 7 were non-obvious due to the prior art not suggesting the claimed DNAs, and while claims 4 and 6 were considered broad, the prior art did not render the claimed genus obvious. The court did not address the enablement requirement for claims 4 and 6, but noted potential inadequate support in the patent application. Ultimately, the court reversed the rejection of claims 4, 7, and the patent was not deemed unpatentable.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class behind.